friends. Today we're going to discuss about an important case, that is Osheroff versus Chestnut Lodge. This is a case law with regard to psychotherapy which occurred in USA. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. This presentation revolves around an important publication titled as Psychiatric Patients' Right to Effective Treatment, Implications from Osheroff versus Chestnut Lodge. This was published in 2022 in a journal called as Focus. Actually, the original article is published in American Journal of Psychiatry in 1990, and it's a republication in 2022. The reason is the issues with regard to psychotherapy and legal issues are cropping up. Hence, it was republished in 2022. To download this article, please scan this QR code. Let's dive into this case. Osheroff versus Chestnut Lodge. In this case, the author of both the paper is Gerald Klerman. He was the treating doctor for Dr. Osheroff. Here, this case brought in a lot of discussion in psychiatric fraternity, psychotherapist, legal, and also in the lay press. If you type Osheroff versus Chestnut Lodge, the case, you will find series of discussions, series of publication in psychiatric journal, and also in psychotherapy journal. Let's discuss about this case. Dr. Raphael Osheroff was a 42-year-old male who was admitted to Chestnut Lodge, basically an hospital in Washington. When he was admitted in 1979 with the following symptoms: he had depressive symptoms, he had anxiety symptoms, and he was treated on OPD basis for longer duration. He had completed his MBBS, he had finished his intern, and he was certified under the subspecialty for nephrology. He was married and had 3 children. One was with the current wife, and the 2 was with the ex-wife. That means he was divorced. Dr. Osheroff, who was suffering from severe anxiety and depressive symptoms approximately 2 years. He was treated on outpatient basis, both with psychotherapy and tricyclic antidepressant, because it is 1979. The patient, however, did not take medicine as recommended. He had decreased medicine and stopped. Hence, he had a worsening of symptoms, and he was hospitalized in Chestnut Lodge. The reason for admission was severe relapse. And he was admitted in 1979, and he was there in the Chestnut Lodge hospital for 7 months. During his inpatient, he was treated with individual psychotherapy 4 times a week. That means every session lasted for 45 to 60 minutes, 4 sessions per week. That approximately per month will be 12 to 14, and even for 6 months will be 70 to 90 sessions were done. There was no medication was given. He lost 40 pounds. He had severe insomnia, marked psychomotor agitation. His agitation manifested in the form of pacing up and down, and also because of this extreme agitation, he had developed blisters on his sole, that is on his feet. He required medical attention for this. Family consulted a psychiatrist in Washington, D.C. area to speak about that he is not improving. In response, the Washington, D.C. psychiatrist spoke to Chestnut Lodge Chestnut Lodge psychiatrist and the treating team. Hence, they conducted a clinical case conference, and they decided to continue with individual psychotherapy. No medication was started. He further worsened. Finally, the family took discharge from Chestnut Lodge Chestnut Lodge Hospital, and he was admitted to Silver Hills Foundation in Connecticut. From there, he was treated with phenothiazines and tricyclic antidepressant. Within 3 months, he completely remitted. In 1982, he initiated a legal action against the Chestnut Lodge Hospital for improper treatment, long inpatient care. He lost his lucrative practice as a nephrologist, and during this period, he even lost the custody of his 2 children. The ex-wife was divorced, presented to the court telling that he is severely ill, he is inside the psychiatric hospital, and she took both the children and left to Europe. Osheroff was devastated at this time, and he instituted a case against the Chestnut Lodge. Many experts were called in. A financial damage suit also was filed. The Dr. Osheroff requested a jury trial, which was taken place in October 1987. And if you look at the various lay press, the first decision came around. The compensation was around $5.5 lakh were supposed to be paid to Dr. Osheroff, but later it was revised. Hence, Dr. Osheroff made an appeal to the court and asked the jury trial should be conducted. However, before the action could take place, Dr. Osheroff and the Chestnut Lodge Hospital did an out-of-court settlement for undisclosed amount. Here, there are various issues came into picture. First and the foremost, the agitated depression as a diagnosis was accepted by both the team, that is, Chestnut Lodge Hospital and also Silver Hill Hospital. The main issue was diagnosis of narcissistic personality disorder, which was made in the Chestnut Lodge Hospital, was not accepted by the Silver Hill Hospital. Further, the Silver Hill Hospital also challenged giving only psychotherapy for a severely depressed patient was challenged. And they also challenged giving only psychotherapy in agitated depression was not considered safe. Hence, from the legality point of view, wrong diagnosis of personality disorder, and the clinical team persisted with individual psychotherapy even when a specialist requested for revision of the diagnosis and treatment, which led to longer duration of inpatient, 70 to 90 sessions of individual psychotherapy at that time. So, considering this, there was an out-of-court settlement, discussion occurring in the lay press and also in the psychiatric journal. The author of this article, Gerald Klerman, clearly said that we need to use ICD or DSM-4 diagnosis so that inter-rater reliability will be very high. Further, we need to provide alternative discussion with regard to treatment. Insisting that only psychotherapy to be given, only medication to be given is unethical. That's what the author has proposed. And also, it is the responsibility of the psychiatrist to give effective treatment and communicate to the patient. Further, the psychiatrist also has a responsibility to modify the treatment plan or seek consultation if the patient does not improve. That means, imagine if you are giving a treatment and in spite of 2 to 3 months, if it doesn't improve, you need to change the treatment, or else you need to ask your colleague for a second opinion or refer him to a higher center. And also, we need to take the feedback from the patient and the patient's family member. Further, he also has mentioned we need to take feedback from the patients with regard to therapy, with regard to symptoms, with regard to emotional difficulties, with regard to family and social relationship. During his inpatient stay, Unfortunately, he lost the custody of the two children, which was directly depicted to the long inpatient stay and also severity of the symptoms, which was not addressed adequately when ECT was available at that time and also medications were available. Hence, if the jury trial was conducted at that time, invariably Chestnut Lodge Hospital and the treating team would have been held liable. To conclude, my dear friends, this case highlights the complexity of psychiatric treatment. Psychiatrists should reevaluate the case whenever there is no improvement or worsening of the treatment occurs. In the era of rights-based, at this point of time, it is a rights-based mental health care. And also it is a consumer era. All professionals providing care to persons with mental illness can be held accountable for professional negligence. Invariably in India, Consumer Protection Act will come into play. Hence, we need to bring reasonable skills, reasonable knowledge, and care to the table so that the patient gets the effective treatment. Thank you very much for your valuable time. Stay safe.